The Supreme Court just issued an 8-1 decision that has the media declaring a total defeat for Missouri's Second Amendment Preservation Act. Headlines are everywhere saying the gun rights rebellion is over, but if you look at the headlines, you're missing the actual legal war being waged in the fine print. While the media is focused on the 8, you need to be focused on the 1. Justice Clarence Thomas, and a specific high-voltage statement dropped by Gorsuch and Alito that completely flips the script. This isn't a final defeat, it's a strategic setup. So hit subscribe, because what's actually happening behind the scenes at the Supreme Court is a roadmap for how gun rights will be protected in the face of federal overreach. Let me break down exactly what the Supreme Court decided, because the details here matter more than the headlines suggest. Most reports make it sound like the Supreme Court just ruled Missouri's law is unconstitutional. That is false. What actually happened was an emergency application. Missouri went to the High Court asking for a stay, basically a pause, on a lower court's injunction. A federal district judge had blocked the law, and Missouri wanted that block lifted while the case moves through the appeals process. In an 8-1 vote, the court said no. They refused to lift the block for now. Only Justice Clarence Thomas stood alone, signaling he was ready to protect Missouri's sovereignty immediately. But here is the critical part that changes everything. This wasn't a ruling on the merits. The 8 justices didn't say the law was bad. They signaled they wanted the lower courts to fully develop the record before the Supreme Court takes a final swing. It's a tactical delay, not a final execution. When 8 justices agree on something, especially in an emergency context like this, it usually signals they want the case to work its way through the normal appeals process before making a definitive call. Think of it like this. The justices are saying, we're not ready to make a call on this yet. Let the factual record get built up in the lower courts, and we'll see you later. This type of emergency application doesn't include full oral arguments or extensive written briefs. Missouri filed this after losing at both the district court level and the 8th Circuit Court of Appeals, forcing them to seek emergency relief from the nation's highest court. Justice Clarence Thomas being the lone vote to grant the stay is significant. Thomas has spent decades building a jurisprudence of state sovereignty. To him, this isn't just about guns, it's about the 10th Amendment. The powers not delegated to the United States by the Constitution are reserved to the states respectively or to the people. By voting to grant the stay, Thomas is signaling that Missouri has a likelihood of success. He likely views Missouri's refusal to help federal agents as a core right of the state. Thomas has a long and consistent record of supporting both state sovereignty and Second Amendment rights. In a 2012 case called National Federation of Independent Business versus Sebelius, the Affordable Care Act case, Thomas wrote extensively about the limits of federal power and the reserved authority of states under the 10th Amendment. He's consistently argued that the federal government cannot commandeer state officials to enforce federal programs. That anti-commandeering principle applies directly to Missouri's situation. The timing of Thomas's vote is also significant. It came just months after he wrote the majority opinion in New York State Rifle and Pistol Association versus Bruin, one of the strongest Second Amendment victories in Supreme Court history. That case struck down New York's concealed carry licensing system and established that gun regulations must be consistent with the nation's historical tradition of firearms regulation. If Thomas believes that many current federal gun regulations violate the Second Amendment under the historical standard he established in Bruin, it makes perfect sense that he'd support Missouri's attempt to resist those regulations. While the other conservative justices, Kavanaugh, Barrett, and Roberts, voted to deny the stay, it doesn't mean they disagree with the law. It means they are playing the long game, waiting for a cleaner case to establish a permanent precedent. But Thomas standing alone on this vote reveals something important about the current Supreme Court. Even the other conservative justices who voted with him in Bruin weren't ready to support Missouri's law at this emergency stage. That suggests they see a meaningful difference between striking down a state law that restricts gun rights and allowing a state to actively structure enforcement this way. So, what is this law that has the federal government so terrified? It's called House Bill 85, better known as the Second Amendment Preservation Act. Missouri didn't just pass a feel-good resolution, they built a legal fortress. Missouri passed this in 2021, and it's not your typical gun rights legislation. This law goes further than anything any state has attempted in the Second Amendment context. At its core, SAPA makes a bold declaration: federal gun regulations that exceed constitutional authority, things like certain registration requirements, tracking, or bans on specific accessories, are invalid within Missouri's borders. The law specifically targets federal regulations that restrict the manufacturing, ownership, or use of firearms when those activities happen entirely within Missouri. This isn't just a symbolic statement. This law created actual enforceable penalties against state officials who cooperate with federal gun enforcement. The legislation came after years of mounting frustration among Missouri lawmakers who believed federal agencies were systematically overstepping Second Amendment protections. Between 2008 and 2021, the ATF proposed or implemented over 15 major regulatory changes affecting firearms. We're talking about bump stock bans, pistol brace regulations, ghost gun restrictions, and numerous other rules that many gun rights advocates viewed as constitutional overreach. Missouri's lawmakers looked at this trajectory and decided they needed to draw a hard line. But here is the real teeth of the law. The prohibitions. Under SAPA, state and local officers are strictly forbidden from using personnel. No local cops helping ATF raids. They cannot use facilities. No using state booking stations for federal gun charges. They cannot use resources. No sharing database info or equipment. The goal is simple but revolutionary: logistical starvation. Let me put this in practical terms. If federal ATF agents want to enforce certain gun regulations in Missouri, they have to do it entirely with federal resources. No help from state police, no assistance from local sheriffs, no use of county jail facilities, no backup from city police departments. The federal government relies heavily on local police to enforce federal law. Missouri is saying, if you want to enforce these unconstitutional rules, you're on your own. Don't call our sheriffs, don't use our desks, and don't expect our help. Missouri lawmakers realize that the federal government doesn't have enough ATF agents to police every street in America. They depend on joint task forces. By pulling the rug out from under these partnerships, Missouri is making federal gun enforcement nearly impossible to execute on a wide scale. It creates a massive friction point. If a federal agent wants to seize a braced pistol in rural Missouri, they can't call the local sheriff for backup or local knowledge. They are walking into a state that has legally divorced itself from the federal gun control apparatus. But as powerful as the non-cooperation part is, it's not what makes the federal government lose sleep. What really has them panicked is the enforcement mechanism, a system so creative it was borrowed from the most controversial law in recent history. We've looked at what SAPA prohibits, but now we have to look at how it actually works. This is where Missouri got creative, and where the federal government started panicking. Most laws are enforced by the government. If you break the law, the state attorney general or a prosecutor sues you. But Missouri realized that if the state enforces SAPA, a federal judge can just issue one big injunction against the state of Missouri and kill the law in a single afternoon. So they did something revolutionary. They took the power of enforcement out of the hands of the government and put it into the hands of you, the private citizen. Under House Bill 85, if a local law enforcement agency or a political subdivision like a city or county knowingly employs an officer who assists federal agents in enforcing these unconstitutional gun laws, they aren't just in trouble with the state. They are liable to private citizens. Any Missouri citizen who has their rights infringed by these federal-local partnerships can file a lawsuit. And the price tag? It's astronomical. The minimum penalty is $50,000 per violation. Legal fees. The agency has to pay the citizens' attorney fees if they win, and there is no cap. There is no limit on how many citizens can sue or how high the damages can go. Think about the math for a second. If a small-town police department with 10 officers helps the ATF on a weekend raid and 10 local citizens sue, that department is looking at a $500,000 bill before they even get to court costs. For a small municipality, that is a bankruptcy-level event. A typical local police department in Missouri might have 20 to 30 officers. If that department assists federal agents in enforcing what Missouri deems an unconstitutional gun law and citizens successfully sue, the liability could reach $1 million to $1.5 million for a single enforcement action. The law is designed to make cooperation with the federal government a financial suicide mission for local police. It effectively creates a bounty system where citizens are incentivized to be the watchdogs of their own local government's compliance with the Second Amendment. The enforcement mechanism operates on a bounty system similar to qui tam whistleblower lawsuits in federal fraud cases. Any citizen with knowledge of a violation can file suit, and if they win, they collect the penalty. This creates an impossible situation for local law enforcement. Imagine being a sheriff in rural Missouri who's worked cooperatively with federal agents for years on joint task forces. Now you have to carefully analyze every single federal request to determine if it involves firearms regulations that Missouri considers unconstitutional. Get it wrong, and you could personally owe $50,000 to whoever sues you. That's exactly the point. Missouri wants federal gun enforcement to become so legally risky that state officials refuse to participate entirely. Missouri didn't pull this idea out of thin air. They looked south to Texas and lifted it almost word for word from Texas Senate Bill 8. You might remember Texas Senate Bill 8, the famous Heartbeat Act. That law banned abortions after a fetal heartbeat is detected, which typically occurs around 6 weeks of pregnancy. But the ban itself wasn't what made legal experts' heads explode, it was the enforcement mechanism. Texas knew that if they had state officials enforce the abortion ban, the courts would block it immediately. So they said, the state won't enforce this, private citizens will sue the providers instead. Instead of having the state attorney general or district attorneys enforce the law through criminal prosecutions, Texas allowed any private citizen to sue anyone who performs an abortion or aids and abets one. The minimum penalty in the Texas law was $10,000 per violation plus attorney fees. The Texas law went into effect in September 2021. And abortion providers immediately tried to challenge it in federal court. But they hit a wall because of how the enforcement was structured. Normally, when you want to stop a state law before it takes effect, you sue the state officials who would enforce it and ask a federal judge to block them with an injunction. It's called a pre-enforcement challenge, but in this case there were no state officials enforcing the law. The enforcement was entirely in the hands of private citizens who hadn't filed any lawsuits yet. The Supreme Court heard the Texas case in December 2021 and issued a decision that shocked legal experts on both sides. The court said you can't get a pre-enforcement injunction against the state because the state isn't the one enforcing the law. The only way to challenge it is to wait until someone actually sues you under the law, then defend yourself and argue the law is unconstitutional as part of your defense. This meant abortion providers had to choose between stopping operations entirely or continuing and risking $10,000 lawsuits from anyone in Texas. Missouri's lawyers saw the success of SB 8 and realized they had found a legal loophole. They studied that Texas decision carefully and realized they could use the exact same structure for Second Amendment rights. If it worked to protect abortion restrictions from federal court challenges, it should work just as well to protect gun rights from federal interference. This is why the federal government is so frustrated. They are trying to fight a ghost. Missouri is trying to replicate that exact whack-a-mole legal environment for gun rights. Missouri adapted the model by changing the dollar amounts from $10,000 to $50,000, changing the subject matter from abortion to firearms, and changing the defendants from abortion providers to state officials who cooperate with federal enforcement. But the core mechanism remained identical: privatized enforcement designed to evade pre-enforcement judicial review. What do you think about this strategy? Should a state have the right to financially penalize its own officers for helping the feds, or does the supremacy clause mean the feds always get their way? Drop a states' rights or federal power in the comments right now. I want to see where you stand on this. Of course, the Biden administration wasn't going to sit back and let Missouri nullify federal law. The Department of Justice sued Missouri in March 2022, just months after the law took effect, and the case landed in front of Judge Brian Wims of the Western District of Missouri. Their argument was straightforward and rooted in one of the most fundamental principles of American constitutional law. Federal law trumps state law. That's the supremacy clause of the Constitution, and it means Missouri can't simply nullify federal regulations it disagrees with. Judge Wims didn't mince words. He struck down the law with a ruling that was extensive, over 60 pages analyzing constitutional history, federalism principles, and the limits of state sovereignty. The judge found that Missouri was essentially attempting to nullify federal law, which the Constitution explicitly prohibits. He issued a preliminary injunction blocking the entire law, but Judge Wims also addressed the Texas strategy. He argued there was a crucial distinction between the Missouri law and the Texas law. The judge specifically rejected Missouri's argument that this law was just like Texas Senate Bill 8. He said the Texas law regulated private conduct between private parties. It prevented private doctors from providing abortions to private patients. States have broad authority under their traditional police powers to regulate private behavior within their borders, even when that regulation touches on constitutional rights. But Missouri's law attempted to regulate federal government operations. It didn't just regulate private conduct. It actively obstructed federal officials from enforcing federal law by threatening state officials with financial ruin if they cooperated. According to Judge Wims, that crosses a constitutional line that even the Texas abortion law didn't approach. To the judge, this was a bridge too far. The injunction prohibited Missouri and all its officers, agents, and employees from enforcing or implementing any part of the Second Amendment Preservation Act. The judge also barred anyone acting in concert with state officials from enforcing it. Missouri immediately appealed to the Eighth Circuit Court of Appeals, arguing that the district court had misunderstood both the law and the constitutional principles at stake. But the Eighth Circuit upheld the injunction, agreeing with the district court that Missouri couldn't obstruct federal enforcement this way. And that leads us back to the Supreme Court's 8-1 refusal to pause that injunction. Right now, as you watch this, SAPA is technically blocked. The state and local officials are under a court order not to implement the $50,000 fines or the non-cooperation mandates. But, and this is the but that changes everything, While the state is blocked, two Supreme Court justices just pointed out a massive hole in that injunction, a hole that might still allow Missouri citizens to sue their local police today. Coming up next, we're going to look at the Gorsuch-Alito roadmap that tells Missouri citizens exactly how to bypass the federal courts. If you only read the headlines, you think Missouri lost 8-1. But if you read the statement of Justice Gorsuch, joined by Justice Alito, you realize they just handed Missouri gun owners a tactical manual on how to keep SAPA alive even while it's blocked. Justice Neil Gorsuch wrote a statement with the denial, and Justice Samuel Alito joined him. This wasn't a dissent. Read that again. They both voted to deny Missouri's stay application, but what they said alongside that vote is absolutely critical. Gorsuch and Alito agreed to deny the stay, but they did so with a critical understanding. Gorsuch wrote that he agreed with denying the stay, but with one crucial understanding about what the district court's injunction actually does and doesn't do. They pointed out that the district court's injunction only prohibits the state of Missouri, its officers, and its employees from enforcing the law. That's it. The injunction does not and cannot bind private citizens who weren't part of the lawsuit. Here is the bombshell. The injunction does not and cannot bind private parties who weren't before the court as defendants in the federal lawsuit. Gorsuch specifically said that any injunction attempting to bind private citizens would be inconsistent with the traditional equitable powers of federal courts. Remember that $50,000 bounty we talked about? Gorsuch and Alito just signaled that the courthouse doors remain open for private Missourians. Because you, the individual citizen, weren't sued by the DOJ, you aren't technically under a federal order to stop filing lawsuits. Gorsuch even cited the Texas abortion case, Whole Woman's Health versus Jackson, to remind everyone that federal courts don't have the equitable power to block a law itself. They can only block specific people from enforcing it. He cited directly to that Supreme Court case about the Texas abortion law we discussed earlier. This is massive, because it means the enforcement mechanism Missouri created is still alive. Private citizens in Missouri can still sue state officials under the Second Amendment Preservation Act. The state government can't enforce the law because they're enjoined by the federal court. The Attorney General can't bring these lawsuits on behalf of the state, but individual Missourians weren't parties to the federal lawsuit, and according to Gorsuch and Alito, they aren't bound by the injunction. Think about what this means in practice. If a Missouri police chief helps federal ATF agents enforce a gun regulation that Missouri's law declares unconstitutional, a private citizen could still file a $50,000 lawsuit against that police chief. The state attorney general can't bring that lawsuit because the state is enjoined. But private citizens aren't enjoined, and Gorsuch and Alito just told them the courthouse doors remain open. This creates a whack-a-mole nightmare for the federal government. If a Missouri police chief helps the ATF today, a private citizen could still drag them into state court for that $50,000 penalty. The federal government would then have to rush into every county courthouse in Missouri to try and stop those individual cases one by one. They don't have the manpower for that. Missouri gun rights supporters aren't just fighting a battle, they are waging a legal insurgency. This transforms the Supreme Court's denial from a clear defeat for Missouri into something far more ambiguous and potentially powerful. Gorsuch and Alito just provided a roadmap, and citizens are free to follow it. Missouri citizens who want to enforce this law can still file lawsuits, and they have explicit guidance from two Supreme Court justices on how to do it. The key is that they must be acting independently, not in concert with the state government. They can't be coordinating with the Attorney General's office or acting as agents of the state. They have to be genuine private citizens exercising their rights under Missouri law. Here's how this could work in practice. Let's say a Missouri citizen learns that their local sheriff's department assisted federal ATF agents in enforcing a pistol brace regulation that Missouri's Second Amendment Preservation Act declares unconstitutional. That citizen files a lawsuit in Missouri State Court seeking $50,000 per officer who participated in the enforcement action. The sheriff's department will almost certainly argue that the federal injunction prohibits this lawsuit, but Gorsuch and Alito just suggested that argument fails because the injunction only binds the state of Missouri and its officials, not private citizens acting on their own initiative. The federal government would then face a difficult strategic choice. They could try to intervene in that state court lawsuit and argue that federal law preempts Missouri's Second Amendment Preservation Act, making the citizens' lawsuit invalid. But that puts them in the position of defending potentially hundreds of individual state court cases across Missouri's 114 counties. Or they could ask the federal district court to expand the injunction to explicitly cover all private enforcement actions. But that's exactly what Gorsuch and Alito suggested would exceed the traditional equitable powers of federal courts. This creates exactly the whack-a-mole problem that the Texas abortion law created. You can't get one big federal injunction that stops everyone. You have to fight each lawsuit individually as they're filed. For the federal government, that's a logistical nightmare because they lack the resources to defend in every county courthouse across Missouri. For Missouri gun rights supporters, it's exactly what they wanted. The case is now back at the 8th Circuit Court of Appeals, and for Missouri, this is good news. The case now returns to the 8th Circuit for full briefing and oral arguments on the merits of Missouri's law. This won't be decided quickly. Federal appeals typically take 6 to 12 months from final briefing to decision, and sometimes longer for complex constitutional cases like this one. The 8th Circuit is widely considered one of the most conservative federal courts in the country. It covers 7 states: Missouri, Arkansas, Iowa, Minnesota, Nebraska, North Dakota, and South Dakota. Statistics show that the 8th Circuit has ruled in favor of Second Amendment claims nearly 75% of the time over the last 15 years. Between 2008 and 2023, the 8th Circuit decided 12 major Second Amendment cases and ruled for the gun rights position in 9 of them. That's compared to the national average of about 55% across all federal circuits. Just recently, they struck down age-based handgun bans, proving they are more than willing to use the history and tradition test established by Justice Thomas in the Bruin decision. Missouri's legal team is heading into this fight with 2 massive weapons. First, standing. They argue the federal government shouldn't even be allowed to sue the state over a law that is enforced by private citizens. Second, the anti-commandeering doctrine. This is the big one. The core of Missouri's argument isn't that they can nullify federal law, it's that the federal government cannot force states to help them. This is based on the landmark case Prince v. United States, where Justice Scalia famously ruled that the feds couldn't force local sheriffs to conduct background checks. Missouri is arguing that SAPA is simply a formal way of saying, "We aren't helping you anymore." They'll point to the anti-commandeering doctrine from Supreme Court cases like Prince v. United States and Murphy v. NCAA. Those cases say the federal government cannot force state officials to enforce federal law or administer federal programs. Missouri will argue their law doesn't violate federal law. It simply refuses to help enforce it, which is exactly what the anti-commandeering doctrine protects. The federal government's counter-argument is that Missouri went too far. It's one thing to refuse to help, it's another thing to punish officers who want to help. The DOJ claims this crosses the line from non-cooperation into active obstruction. They'll emphasize that Missouri went beyond simply refusing to help. The state created financial penalties against officials who choose to cooperate with federal authorities. The law doesn't just protect state sovereignty by allowing non-cooperation. It actively punishes cooperation, turning state officials into hostages who face financial ruin if they work with federal agents. The government will also argue that the private enforcement scheme is a transparent attempt to evade judicial review and should be rejected as inconsistent with constitutional structure, regardless of what the Texas abortion case said. The 8th Circuit recently issued a complex ruling in August 2024, acknowledging Missouri's right to withdraw assistance but still expressing concern about the invalidity language in the law. This ensures that this case is headed for one place and one place only, a final, merit-based showdown at the Supreme Court. This case is a ticking time bomb for the Second Amendment. If Missouri wins, it provides a blueprint for every red state in the union to effectively opt out of federal gun control. Imagine 25 states where federal agents have zero local backup, zero access to state databases, and face $50,000 lawsuits every time they try to enforce a new ATF rule. The federal government knows this is an existential threat to their power. That's why they are fighting so hard to keep the injunction in place. But with Thomas, Alito, and Gorsuch already signaling their positions and the 8th Circuit's conservative lean, the 8-1 loss you saw in the news was actually just the opening bell of a much longer, much more dangerous fight. This case is far from over, and the legal battles ahead will shape the relationship between federal and state power on Second Amendment rights for years to come. This case will shape the future of federalism and your right to bear arms for the next 50 years. What's your prediction? Does the Supreme Court eventually uphold Missouri's right to implement this enforcement mechanism, or will the Supremacy Clause win out? And regardless of how the 8th Circuit rules, will this end up back at the Supreme Court for a final decision on the merits? Let me know in the comments below. If you found this breakdown valuable, hit that like button so you don't miss the updates as this case moves through the courts. I'll see you in the next one.